Others. My Lord, parties absent. I'm not seeing any party online, my Lord.
Respectfully, my Lord. Precious C. Enoch. Precious C. Enoch. Enoch is spelled E-N-O-C-H. My appearance is for the claimant.
May it please
Yes.
this honorable court.
Yes, go ahead.
May it please this honorable court. J.O. Okowe. Okowe is O-K-O-H-U-E.
Okay.
And my appearance is for the first and second defendants.
Okay. So this is the judgment of the court between Mr. Abel Adagba and IPBC Nigeria Ltd and Sir Godi Ibru. This is an action commenced by way of a general form of complaint before the National Industrial Court of Nigeria, Lagos Division, by an amended statement of fact filed on the 16th of February 2023. The claimant, Mr. Abel Adagba, a former supernumerary police officer in brackets spy policeman, posted to the first defendant company claims as follows. 1. A declaration that the defendant's failure to pay the claimant's salary, leave allowance, and gratuity is wrongful. 2. An order that the defendant pay to the claimant jointly and severally the sum of 755,700 being arrears of salaries owed the claimant by the defendant between 2015 to 2018. And 3. An order that the defendant pay to the claimant jointly and severally the sum of 115.847 naira being earned leave allowance while in service. 4. An order that the defendant pay jointly and severally the sum of 2,620,800 naira being gratuity for the 31 years the claimant worked in the defendant company. And 5. An order that the defendant pay jointly and severally 1 million naira only as special damages for the pains, embarrassment, psychological and emotional trauma underwent by the claimant as a result of the way and manner the claimant was treated by the defendant and his staff. And 7. An order that the defendants pay jointly and severally the cost of the action assessed at 1 million naira only. The claimant's case. The claimant's case is that he was employed by the Nigerian Police Force as a spy police constable and posted to the first defendant on the 7th day of June 1988, which was exhibited in Exhibit C1 and D1 later from the Commissioner of Police. His case is also that the first defendant accepted his deployment and confirmed his satisfactory performance by letter dated 1st July 1988, which is Exhibit C2 and /D2, letter of acceptance from the IPBC Nigeria Ltd to the Commissioner of Police. He averred further that before 2011, his salary was paid through the Nigerian Police Force. The first defendant would make advance payment by checks to the Nigerian Police Force, which then distributed salaries to the spy police attached or deployed to the defendant company. He further stated that in 2011, the MD of the first defendant died and a new management headed by Sir Godi Ibru, who is the second defendant in this case, and his son took over. The new management changed the mode of payment. Instead of paying to the Nigerian Police Force, the defendant began paying the claimant's salary directly to him. From 2015, salary payments became irregular and incomplete, leading to accumulation of arrears. His monthly salary was 36,000 naira, 36,400 naira, 400,000 naira paid in cash, which was signed for in the first defendant's accounting books. He maintains that between 2015 and 2018, the defendant owed him accumulated arrears of unpaid salary. He also claims gratuity under the conditions of service for spy policemen, which is 1 year basic salary for every 5 years of service. And having worked for 31 years, he claims his gratuity entitlement is 2.620, 800,000 naira. He, however, admits that the claimant paid half the leave allowance for 2015, but failed to pay for 2016 and 2017, totaling 15,847 naira, which is the outstanding annual leave allowance. That unable to cope with this non-payment, he resigned on the 30th day of April 2018, giving 1 month notice, which he exhibited at the C8, that he petitioned the Office of the Public Defender, which invited the defendant to a meeting, which was declined. He also reported to the Nigerian police, whose invitation the claimant's representative attended and promised to offset the arrears, but subsequently failed to honor the promise. The claimant tendered 10 numbered documents that were admitted and marked as Exhibit C1 to Exhibit C10. The exhibits are all listed in the body of the judgment. I'll now go to the defendant's case. The defendant denied any employment relationship with the claimant, but admitted that the claimant was a spy police officer who was posted and accepted by the first defendant in a letter dated 7 June 1988 and 1 July 1988, respectively, on the mode of salary payment. And when the MD died, the defendant contends that the mode of payment through the police started before 2011, not in 2011, and the MD died in 2009, not 2011. The defendant's case is also that the second defendant did not take over management, neither was he ever directly involved in day-to-day management, despite being a director. That since the claimant had no personal bank account, his stipend was paid through a proxy or collected in cash, and averred that it would rely on payment vouchers showing salary details. Furthermore, that the defendant are not aware of any condition of service and personal emoluments document and did not enter into any such agreement, that no invitation from the Office of the Public Defender was received and no promise was ever made to any police mediation meeting, that the claimant was never asked to resign. It was his personal decision and it was entirely voluntary. The defendant also tendered 2 numbered documents and they were admitted and marked as Exhibit D1 and D2. The defendant, in the body of the judgment, I have the defendant's final written address. I also have the claimant's final written address, as well as the defendant's reply on points of law. I'll go straight to the preliminary issues that were raised before the court's decision. The defendant, in his final written address, raised some issues on jurisdiction, service of originating process, and misjoinder. He submitted that the claimant's suit is incompetent because the originating processes were not properly served on the defendant, therefore depriving the court of jurisdiction to entertain the matter. According to the defendant, he argued that the real issue is whether the originating processes were served on the actual named defendants, not merely whether some form of service occurred. On this issue, this court on the 28th day of November 2024 delivered a ruling, and these issues were resolved in paragraph 18 to 36 of that ruling. The position of the law regarding an issue that has already been resolved in a ruling being subsequently raised for determination in a final written address is that such an issue is generally impermissible for redetermination and will be discountenanced by the court. Thus, to understand this, it is essential to consider the nature and purpose of a final written address, the types of issues that can be properly raised therein, and the finality of the court's ruling. A final written address is an opportunity for parties to summarize their arguments, apply the evidence adduced during the trial of the relevant law, and persuade the court to decide the case in their favor. A ruling by a court signifies its judicial determination or decision on a particular point, often on an interlocutory application, a preliminary objection, or a procedural matter. Once a court has made a ruling on an issue, that issue is considered resolved within the context of that proceeding unless and until that ruling is set aside on appeal. The act of re-raising an issue that has already been resolved in a ruling in a final written address amounts to inviting the court to consider or sit on appeal over its own decision. It is a fundamental principle of judicial administration that the court cannot sit on appeal over its own judgment or ruling. To do so would undermine the finality of judicial decisions and lead to an endless cycle of litigation within the same proceedings. When a party is not satisfied with a ruling, award, or judgment of a court, the primary and most appropriate court of action is to appeal the decision to a higher court. This principle is consistently upheld across various judicial pronouncements in Nigeria. The purpose of an appeal is to seek to overturn, discharge, or vary the decisions of the lower court. See Inakoji versus Adeleke, see Uriah and Turner, see Wuru and Lewin, and Yakubu and Ako. Citations are all provided. While courts are generally duty-bound to consider and resolve every genuine issue properly raised before them for determination, as held in Atomatofa and Atomatofa, and Alawole versus Owobanwe citation provided, an issue that has already been resolved in a prior ruling, ceases to be a genuine issue properly raised for determination in the context of a final written address. In view of the above, authorities cited that decisions held when an issue that has been resolved in a ruling is subsequently raised for determination in the final written address, the position of the law is that such an attempt is improper. In the circumstances, this court finds and holds that all arguments pertaining to this issue is hereby discountenanced, as it has already exercised its judicial function on that point. The appropriate recourse for a party aggrieved by a ruling is to appeal that ruling, not to re-agitate it in a final address before the same court, I so hold. Now to the court decision. The claimant, in proof of this release, have tendered Exhibit C1 to C10. On the other hand, the defendants have argued vehemently that those documents are inadmissible on grounds that they are all photocopies and not admissible under sections 88, 89, and 90 of the Evidence Act, that the documents are unsigned and unauthenticated, that they are not backed by any formal employment process, and made in anticipation of litigation or from unknown sources. The defendants cited Kubo and Dixon and Section 83, Sub 3 of the Evidence Act on the need for documentary evidence to be authentic, certified, and credible. Having considered arguments submitted, this court noted that several of the claimants' exhibit C1, C2, C3, C4, and C5, are the same documents as the defendants' own exhibit D1 and D2, or are documents emanating from the Nigerian Police Force, a public authority. The defendants cannot challenge the admissibility of documents that they themselves tendered or whose contents they acknowledge. The conditions of service document marked as Exhibit C5 emanates from the Commissioner of Police, Lagos State Command, a public authority, and under Section 104 of the Evidence Act, certified copies of public documents are admissible as secondary evidence. As for the claimant's resignation letter, Exhibit C8, it was addressed to the first defendant and is within the claimant's personal knowledge. Its authenticity has not been specifically challenged. Exhibit C9 is a letter from the Office of the Public Defender and is a public document. Section 12 sub B of the Section 12 sub 2 sub B of the NICN Act 206 gives this court a degree of flexibility in employment and labor matters. While the court is generally bound by the Evidence Act, it may relax strict evidential rules where doing so would serve the interest of justice. The provision has been relied upon by the NICN in cases involving admissibility of electronically generated documents, workplace records, employment-related documents where strict proof may be difficult, labor and industrial relations disputes arising requiring substantial justice over technicalities. This court is convinced that the defendant's objection to admissibility is largely without merit in the NICN context, particularly regarding documents that the defendant themselves acknowledge or that emanate from public authorities. This being the case, can those documents then be used by the claimant to claim the relief sought? Now, to the substantive issues. The parties before this court are Mr. Abel Adagba, a former spy policeman posted to the first defendant on the 7th day of June 1988 until his resignation on the 30th day of April 2018. The first defendant is IPBC Nigeria Limited, to which the claimant was posted to. The second defendant, Sir Godi Ibru, described by the claimant as the chairman and CEO of the first defendant and alleged to be the alter ego of the company. The first issue to determine is whether the claimant was an employee of the first defendant. The first defendant has maintained that he was not the employer of the employer. He cited authorities establishing that spy police officers remain employees of the Nigerian Police Force, not of the entities to which they are posted. The authorities cited by the defendants as Shell versus Dino, Shell versus Adiko, Mobile versus Udo, Fidelity Bank versus Olarewaju, which all citations were all provided, which all represent the settled position of Nigerian law to the Supreme Court level. A comprehensive reading of the authorities cited, like Shell and Dino, extensively reproducing Section 2, 18, 19, 20, 21, and 22 of the Police Act, the court held that supernumerary police officers are members of the Nigerian Police Force and are never servants of the appellant. In Shell versus Adiko, the Court of Appeal also held that it seems to be settled law that supernumerary police officers are not the employees of the organization to which they have been assigned. In the case of Fidelity Bank and Olarewaju, The Supreme Court held that spy police officers are not employees of the persons who avail themselves of their services. Rather, they remain officers of the Nigerian Police Force. And I quote, by virtue of the combined provisions of Section 215 sub 2 of the Constitution of the Federal Republic of Nigeria 1999 and Section 18 sub 3 sub D of the Police Act 1990, all police officers, including supernumerary police officers, are employees of the government and subject to the control of the IGP and the Commissioner of Police in their various states of service. End of quotation. The defendant further relied on the admission of the claimant during cross-examination that the first defendant could not set up an orderly room trial to discipline him. Only the police force could do so. Neither could the first defendant hire or fire him. These admissions, the defendant argued, reinforced their position that no employer-employee relationship existed between parties. Now, the court resorted to the Police Act in resolving this issue. Section 2 states that a supernumerary police officer is a member of the Nigerian Police Force. He is appointed by the IGP, and his appointment is determinable only by the appropriate authority, which is the Nigerian Police Council. More importantly, is the statutory provision under Section 18 sub 4 that the entity availing itself of its services pays its salary to the Accountant General and can only request withdrawal of services, not termination of appointment. The combined effect of all these provisions, as interpreted by the Supreme Court and the Court of Appeal in the above mentioned cases, that is Shell and Dino, Shell and Adiku, Mobile, Anudo, and Fidelity Bank, and Olawurwaju, indicate that indeed the employment posting letter Exhibit C1 is not a contract between the claimant and the first defendant. It is a communication between the first defendant and the police. No employer-employee relationship exists between a spy police officer and the entity to which he is posted. I so find and hold. It must be noted that the claimant's case, however, introduces a critical distinguishing factor, which he averred to, that in 2011, the mode of payment changed. The claimant avers that from 2011, the defendant stopped paying through the Nigerian Police Force and began paying him directly. The claimant argues in paragraph 25 of his statement of fact that, and I quote, by the defendant undertaking in 2011 to be paying the salaries of the claimant directly and actually paying same, the defendant became liable personally and directly to the claimant for recovery of unpaid salaries, allowances, and gratuity. End of quotation. Section 18 sub 4 of the Police Act provides thus, and I quote, where any supernumerary police officer is appointed under this section, the person availing himself of the service of that officer shall pay to the Accountant General, 1, on the enlistment of the officer, the full cost of the officer's uniform, and 2, quarterly in advance, a sum equal to the aggregate of the amount of the officer's pay for that quarter in question, and such additional amount as the IGP may direct to be paid in respect of the maintenance of the officer during that quarter. End of quotation. It must be stated that the statutory framework under the Police Act cannot be altered by the unilateral conduct of the parties. The fact that the defendants chose to pay the claimant directly rather than through the Nigerian Police Force does not transform the legal relationship. I so hold. The Apex Court, having determined that the claimant remained an employee of the Nigerian Police Force regardless of the payment channel, the follow-up question is whether he is entitled to the claim for salary. An employee's entitlement to salary in Nigeria is primarily governed by the terms of their employment contract, statutory provisions, and judicial pronouncement. The fundamental principle established by the Nigerian court is that an employee is entitled to salary and wages for services lawfully rendered during the period of their engagement. This entitlement is directly linked to the performance of work. The law is that an employer who engages an employee under agreed terms cannot refuse to pay earned wages without legal justification. Where an employee proves the existence of a contract of employment and establishes entitlement under the contract, the court will ordinarily order payment of the assigned salaries and allowances. Accordingly, the prevailing legal position is that salary is a vested contractual entitlement that becomes payable in accordance with the employment contract, and an employer who fails to pay without lawful justification will be liable for breach of contract and recovery of the outstanding wages. In the instant case, the defendant in paragraph 4 sub of the statement of defense stated that payment through Nigerian Police Force started before 2011, and I quote, started before 2011, end of quotation. By and large, it can be inferred that parties are in agreement that the direct payment spanned approximately for 7 years, that's 2011 to 2018. In other words, the defendant arguably created a direct obligation to the claimant regarding the payments which undertook to make, as stated in paragraph 4C of the statement of defense, to which the defendant averred they would rely on payment vouchers during which during trial, which was never tendered, by the way. For the period of non-payment of salary, the claimant asserts that the backlog of salaries accumulated from 2015 until 2019, which led claimant to resign due to the defendant's failure to meet their financial obligation. The failure to pay earned wages is a fundamental breach of an employment contract and a violation of statutory labor protection. The defendants have not provided any legal justification for withholding the claimant's leave allowances after decades of service. The involvement of the Office of the Public Defender, which is exhibited by Exhibit 7, C7, collaborates the existence of a legitimate grievance regarding unpaid entitlement. The claimant claimed the duration of his service was from pleaded in paragraph 13 of his statement of fact that from 2015, his monthly salary was 35,000 naira, and in paragraph 15, he avers that between 2015 and 2016, he was owed 755,700 naira in arrears of salaries. The defendants, however, failed to produce credible documentary evidence of payment. The position of the law is that an employer, that is the defendant in this case, bears the legal burden of proving that they discharge their obligation to pay, that is the claimant's entitlement. The defendant assertion that payments were made in cash or through a third party, in bracket the next in command, is a positive assertion that requires strict proof. The lack of a bank account by the claimant does not absolve the defendant of the duty to maintain proper accounting records for cash disbursement. In the absence of signed vouchers, receipts, or bank transfer records, the question whether the claimant rendered services is not in dispute, and the defendant, having voluntarily assumed the obligation of direct payment, paragraph 4C of the statement of defense, this court will, in the circumstance, invoke the principle of estoppel by conduct under section 169 of the Evidence Act to stop the defendant from any attempt to deny the claimant of his entitlement to claims for salary. This court is therefore swayed by the submission and the evidence tendered by the claimant that he is entitled to his salary, therefore failure to pay him is unlawful. I so find and hold. On the issue of leave allowance and gratuity, the claimant relied on the condition of service for spy policemen, Exhibit C5, issued by the Commissioner of Police, the claimant's employer, Lagos State Command, which provides us, and I quote, A, apart from all remuneration, the spy policemen are entitled to all allowances as applicable to the company or establishment to which they are deployed. 2, gratuity paid to them by the establishment of or company to which they are deployed after they have served for a period of 5 years and above. And 3, entitled to 21 working days leave annually and 10% of their annual basic salary as leave grant. This letter originally imposes obligations on the defendant regarding leave allowance and gratuity and creates a tripartite obligation for the entity benefiting from the services. The question remains whether the defendants have a separate obligation to the claimant arising from the conditions of service document, which is Exhibit C5, and which clearly imposes obligation on the defendant. In defense of this claim, the defendants have in their statement of defense, paragraph 4D, stated that they were not aware of the conditions of service. The court, however, noted that what is tendered before this court are 1, communication to from the defendant. The communication the defendant had with the Nigerian police force after the deployment was the acceptance letter Exhibit C to the 1st of July 1988. The 2 other letters dated 6 February 1989 and 7th of February 1989, tendered as Exhibit C3 and C4, were forwarding bankers' checks to the Nigerian police force and confirming that the claimant was still serving in the defendant company. Whether the amount reflected on the paycheck covered leave allowance or gratuity or just the basic salary of the spy police working for the first defendant, this fact was never disclosed to the court. The court, however, noted that although Section 18 sub 1 of the Police Act provides for statutory framework for the existence and appointment of spy leave or promotion criteria for spy police, they are not rooted in the Police Act. Section 48 of the Police Act generally extends the provisions of the Act to all persons serving in the police force for purposes of gratuities and pension, which indicates a broad application of the Act's provision to those serving within the police structure, which would which could potentially involve spy police officers. If for a moment the court is persuaded by the argument of the defendant that they were not aware of the conditions of service of the Nigerian police force tendered by the claimant, then the question would be, under what conditions did the claimant serve under the defendant? Not being aware of these conditions of service does not absolve the defendant of the obligation to ensure that basic minimum work standard is maintained. In Nigeria, the Labour Act is a fundamental piece of legislation designed to regulate the relationship between employers and employees, ensuring fair labour practices and protecting the rights and welfare of workers. The Labour Act is not an exhaustive code that replaces all other laws relating to employment or public safety. Instead, it functions as a foundational statute that complements other legislation. The Act regulates employment conditions, establishes minimum standards for terms of employment, wages, working hours, fair treatment, safe working environments, and adequate living conditions for laborers and other aspects of the employer-employee relationship. Through all these mechanisms, the Labour Act serves as a critical instrument for fostering industrial harmony, promoting social justice, and upholding the dignity of labor in Nigeria. In the instant case, the claimant is seeking for a declaration that failure to pay him salary, leave allowance, and gratuity is wrongful. Under the Labour Act, Section 18 deals with annual leave. It provides that every worker who has completed 12 months of continuous service is entitled to annual leave with full pay, while Section 19 provides that during annual leave, a worker is entitled to receive his normal wages, excluding overtime, and the worker does not suffer a reduction in earnings merely because he is on statutory annual leave or approved sick leave. In essence, where an employee claims unpaid leave allowance or leave benefit, Section 18 supports the employee's right to annual leave, especially if he can show that he completed the required period of service and the leave benefit was not paid or granted in accordance with the contract or applicable law. See Section 19, which governs how the leave pay should be calculated. In the instant case, going by the Labour Act, it is not in dispute that Abel Adagba completed more than 12 months of continuous service. In fact, both parties agree he spent nothing less than 30 years in service until his resignation. Secondly, the defendants countered the claimant's averment in paragraph 18 of the statement of fact that, and I quote, the defendant paid half of the leave allowance for 2015, end of quotation, but they are yet to pay the leave allowance for 2016 and 2017 in the sum of 115,000 naira 884 115,884 naira. The defendant, in the face of all these amendments, submitted in their statement of defense that it was never aware of the conditions of service to pay annual leave allowance. This denial of knowledge presupposes that claimant was never paid leave allowance, which is a statutory requirement. Even the half salary allegedly claimed to have been paid, the defendant failed to report it. Rather, a blanket denial of his knowledge was its defense. In civil pleadings, a defendant is required to deal specifically with each allegation of fact to which he does not admit the truth. A general traverse is insufficient to deny a specific allegation of fact. A general or a blanket denial does not raise the triable issue. It is deemed an admission of the fact alleged. See Messrs. Lewis and Pitt versus Akinmehi, citations provided, where the Supreme Court held that a general denial of a specific allegation of fact is evasive and constitutes an admission of the fact. The denial must answer the point of substance and not the evasive. See UBA again. See again UBA versus Jara Gaba. Citation provided. The Supreme Court, where the Supreme Court reiterated that the defendant must answer the point of substance and not deny an allegation of fact evasively, as an evasive denial is taken as an admission. The defendant has stated that he will be relying on payment vouchers to support its case. This position, if it had been sincere, would have made the facts clearer to the court. But to the dismay of the court, no voucher or document was tendered during trial. In the circumstance, this court would invoke Section 167 of the Evidence Act and presume that the content of the document would have been unfavorable to the defendant if produced. It is therefore admitted and not in doubt that the defendant is owing the claimant the outstanding leave allowance. This being the case, this court is convinced that failure to pay the claimant his leave allowance was equally wrongful. I so find, hold, and declare. Now, with regards to gratuity, the Labour Act does not expressly create a general statutory right to gratuity for all employees. The relevant provision in Section 9, sub 7 of the Labour Act, which provides that the written contract of employment shall specify any conditions relating to benefits, including provisions concerning incapacity to work due to illness, sickness or injury, pension, and gratuity. In essence, the Labour Act recognizes that gratuity may form part of an employee's terms and conditions of employment. However, it does not prescribe a mandatory gratuity scheme or a formula for calculating gratuity. An employee is entitled to gratuity only when he can prove it is provided for in the employment contract contained in the collective, that it is contained in the collective agreement, the company policy, condition of service, or handbook, or it exists in customary practice or created by a specific statute governing that employment, and that, more importantly, he satisfies the conditions for receiving it. The position of Nigerian court is that gratuity is a contractual entitlement, not an automatic statutory entitlement. A court will not award gratuity merely because an employee worked for so many years. If no document or established practice creating gratuity is proved, the claim is likely to fail. Applying this to Adagba's case, the issue of gratuity is a thorny one. In the absence of a direct employer-employee relationship under Section 18, sub 4 of the Police Act, this question is whether the entity that benefited from his supernumerary services for over 30 years is obligated to pay the officer's gratuity. The claimant's argument is that the condition of service document was issued by the Commissioner of Police, the same authority that posted him, that it represents the terms under which the first defendant was permitted to avail himself of the claimant's services. The first defendant, having accepted these terms by accepting the claimant's posting and utilizing his services for 30 years and paying the claimant's salary initially through the police force, then directly from 2011, the principle of estoppel by conduct applies. Having accepted and acted on the conditions for 30 years, the first defendant cannot now deny their existence or applicability. The Supreme Court has unequivocally held that all police officers, including supernumerary police officers, are employees of the government and are subject to the control of the IGP and the Commissioner of Police in their respective states of service, as affirmed in Fidelity Bank and Olarowaju, which referenced sections 2152 of the 1999 Constitution of the Federal Republic of Nigeria and Section 18 sub 3 and D of the Police Act. In addition to all the several Court of Appeal decisions as stated above, it reinforces this principle, stating that spy police officers are not employees of the organizations to which they have been assigned. Instead, they remain employees of the Nigerian Police Force, and no employer-employee relationship exists between them and such organization. In fact, the Apex Court had described spy police as a constabulary created by the government to perform supernumerary functions. While the provided legal context does not explicitly mention gratuity in relation to spy police officers, the established legal position is that they are employees of government, and the Nigerian Police Force has direct implications for their entitlement. Their terms and conditions of service, including benefits such as gratuity, will be governed by the regulation and schemes applicable to personnel of the Nigerian Police Force. The private organization or government department that applies for and utilizes their services, even if it contributes to their salaries or uniform, does not become their employer and is therefore not directly liable for their gratuity or other terminal benefits. This benefit will typically be administered by the Nigerian Police Force in line with the public service rules and regulations governing police personnel. So the position of the law regarding gratuity for spy police officers is derived from this established legal status as employees of the government and the Nigerian Police Force, rather than private organizations or government departments to which they are assigned. Consequently, Relief 1 succeeds to the extent that this court declares that the defendant's failure to pay the claimant's salary and leave allowance is wrongful. With regards to gratuity, this court declines to grant this part of the declaration in view of the reasoning stated above. I so find and I hold. Consequently, Relief D for the payment of 620,800 naira for gratuity for 31 years fails, I so hold. Now, in addressing the relief, so the claimant is seeking for the sum of 755,700 naira being arrears of salaries between 2015 and 2018. The fundamental principle of law is that he who accepts must prove. Therefore, the worker, as the claimant now, asserting a claim for outstanding salary, bears the initial burden of proving their entitlement to the salary and the specific quantum of the sum claimed. This involves demonstrating the existence of an employment relationship, the agreed salary, and the period for which the salary is alleged to be outstanding. The NICN has consistently held that in labor relations, the burden is on the claimant who claims monetary sums to prove not only the entitlement to the sums, but also how they arrive at the quantum of the sums. Proof of entitlement is often by reference to an instrument or document that grants it. The claimant must provide sufficient particulars of their claim for salaries to enable the court to calculate the amount. This position was affirmed in Habib and Coral International Ltd, and Equem and Unity Bank, and Ngilari versus Adamawa State. Citations are all provided. In a claim where a worker alleges outstanding salary and the employer asserts that payment has been made, the burden of proof operates in a dynamic manner, initially resting on the employer and then shifting to the worker and then shifting to the employer. In the earlier part of this judgment, the court held that although the first defendant had no employment relationship with the claimant, the posting of the claimant by the Nigerian Police Force to the first defendant was a unique species of employment. And the first defendant was obligated to pay his salaries. The claimant tendered Exhibit C1, which was his employment/posting letter with effect from 07/06/1988. His salary and allowances were stated as follows. One, salary per annum was 17,520 naira. The rent payable was 360 naira. The transport allowance was 960 naira, and the torchlight allowance was 48 naira. The claimant also tendered Exhibit C2, which is the acceptance letter from the defendant. Before this court is also Exhibit C3, a letter forwarding a banker's check to the Nigerian Police for salaries of spy police constables serving with IPBC. Exhibit C4 is a confirmation letter to the police force that the claimant listed as number 11, amongst others, were attached to the first defendant. On the part of the defendant, the first defendant's own letter, Exhibit D2, acknowledges the claimant's services and recommends his inclusion for salary payment. The admission by defendant of the direct payment arrangement from 2011 creates at minimum an obligation to account for payments made and outstanding. The first defendant also admitted through his statement of defense, paragraph 4, sub C, that the claimant, and I quote, sometimes collects his stipend in cash, and that the payment voucher evidencing salary details will be relied upon during trial, end of quotation. This, to the mind of the court, is an admission that the first defendant made direct payments to the claimant. The defendant's failure to provide documentary evidence of payment through vouchers or receipts violates standard accounting practices and legal expectations for corporate entities, leading to the conclusion that the arrears remained unpaid. The defendant had signaled their intent to rely on payment vouchers. Under Nigerian Labour Law and the Labour Act, employers are required to keep records of payment. If the defendants cannot produce vouchers or receipts signed by the claimant or his authorized proxy, this defense of payment may fail. The law is also that once the worker has discharged that initial burden by establishing a prima facie case of entitlement to the salary and that it remains unpaid, the burden of proof shifts to the employer to demonstrate that the salary was indeed paid. The defendant had averred that payment, I quote, payment voucher evidencing salary details will be relied upon during trial. End of quotation. This payment voucher was, however, never tendered before this court. The law is settled that the court is allowed to presume that the document not produced is unfavorable to the party or to produce it. See Adamawa and State, see Aremu and Adetoro, and also SSG, MBH, and TD Limited. And also Olojak versus the Governor of Benue State. Citations are all provided. This was the same principle in Shell and Tiebo the 7th. In the instant case, the defendant in his pleading averred that he would rely on payment vouchers to counter the claims for outstanding salary, but failed to tender the said document. This court would therefore deduce that its non-production meant that if produced, it would have been unfavorable to the appellant in accordance with Section 167 of the Evidence Act, and relying on the authority cited above, this court cannot speculate on the content of the document not produced before it. See Gajo versus Ogumbo Regi. Citation provided. Referred to per Onalaja JCA at page 108, paragraph A to B, and also Uzuegbo and Progress Bank Nigeria Limited. Citation also provided. The principle that the burden of proof is not static and shifts from time to time is further reiterated in Mato and Admiral Environmental Care Ltd and Suleiman and Abubakar Tafawa Balewa University Bauchi citations all provided. In a claim for arrears of salary and employment benefit, the burden of proof rests squarely on the claimant pursuant to Section 131 and 132 of the Evidence Act. The claimant must prove not only the existence of the employment relation, but also the specific terms of the contract that entitle him to the sums claimed. Conversely, where a claimant alleges non-payment of earned wages and the defendant asserts that payment was made, the burden shifts to the defendant to prove payment. Section 131 of the Evidence Act provides that whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove those facts. This shifting nature of the burden is also enshrined in Section 136 of the Evidence Act, which states that the burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence. Nigerian courts have consistently applied this principle in salary disputes. The Supreme Court in Honica Sawmill versus Hof held that the burden lay on the appellant, in bracket the employer, to show what and how much by way of salary was paid to the respondent. The court emphasized that this burden had not been discharged. The Court of Appeal in Ijesu Food and Guinness held that the employer carried the burden of proving that it had paid the outstanding amount claimed by the respondent. Similarly, in Bolu versus FCE Obudu, concerning a claim for salary in lieu of notice, the Court of Appeal stated that the burden was on the party who had said the affirmative, the employer in this case, to show that they actually paid the said sum. More recently is the case of Naok Ltd versus Esumai and others, where the Court of Appeal reaffirmed the general principle that burden is on he who has said. It is the considered view of this court that the claimant has been able to establish that the defendant, having failed to discharge the burden and prove that salaries were paid to the claimant, then the defendant indeed owes arrears of salary between 2015 to 2018 in the sum of 755,700 naira. I so hold relief C succeeds. For the relief for leave allowance, while in service, the claimant has pleaded that his leave allowance was never paid. The defendant in this defense submitted it was never aware of the circular to pay the leave allowance, and the court had earlier referred to the provisions of the Labour Act and made a declaration that failure to pay the claimant's leave allowance when the parties are in agreement that he completed more than 12 months in the employment of the defendant was wrongful. In the circumstance, relief C succeeds, and the court hereby makes an order that the defendant pay to the claimant the sum of 155,847. I so hold. In relief E, there is a claim for special damages for the pains, embarrassment, psychological and emotional trauma as a result of the way and manner he was treated by the defendant. The claim for special damages in labor relation must meet the twin requirements in both its pleadings and deposition as to entitlement and how the quantum of the sums claimed was arrived at. See Suraju Rufai and Bureau of Public Enterprise unreported suit number NICN LA/18/2013, the judgment of which was delivered on the 4th day of June 2018, and Mr. Dongus versus ENL Consortium Ltd 2015 60 NLR Part 20839. A fundamental term of any employment contract is the employee's obligation employer's obligation to pay wages for services rendered. Failure to pay wages constitutes a material breach of contract under the principle of quantum merit and the provisions of the Labour Act. An employee is entitled to be paid for work done. Under the principle of quantum merit and the provisions of the Labour Act, an employee is entitled to be paid for work done. The court found that the defendant's act of withholding salaries was a wrongful act indeed. Furthermore, the claimant's resignation due to non-payment of salary can be viewed through the lens of constructive dismissal, where an employer's conduct like withholding pay makes it impossible for the employee to continue. The claimant in his pleading averred in paragraph 1920 that non-payment made him to stop work on the 30th day of April 2018, he could not afford transport fare to and from work and could no longer cater for his family needs. In paragraph 21, he averts all appeals to be paid failed, which led to his petition at the Office of the Public Defender, and the invite tendered as Exhibit C9 was never honored. Neither were promises made at the police station to offset the arrears ever fulfilled. They said arrears of salary between 2015 to 2018, which is 755,700 naira, and earned leave allowance, which is 115,847 naira, were reflected in the reliefs claimed by the claimant. A court can only grant a relief that is claimed. See Gabriel Active versus Cable Meta. These reliefs were collaborated by credible documentary evidenced in Exhibit C5 to C7. In the circumstance, special damages is granted in the sum of 500,000 naira only. Relief E succeeds. For Relief 6, which is the cost of 1 million naira, on that note, given the age of the suit filed and prosecuted since 2020, and the established evidence that there is no basis for the defendant to have withheld payments of the claimant's salary and leave allowance on the pretext that it was not aware of the conditions of service, the law is settled that ignorance of the law is no excuse. The defendant had HR officers who communicated with the Nigerian police force in Exhibit C2, C3, and C4, and went ahead to wrongfully withhold the claimant's benefit since 2018. In Niamey versus Federal Republic of Nigeria, citation provided, the Supreme Court held that ignorance of the law has never afforded anybody an excuse, for everybody is supposed to know the law. See also Cedar Stationaries Ltd and Ibual Ltd, and in Oworu versus Adigo, citations are all provided. The Supreme Court even extended this principle to learned counsel who, being an officer of the court in the Temple of Justice, should know better. In the circumstance, cost in the sum of 500,000 naira is hereby awarded in favor of the claimant against the defendant, pursuant to Order 55, Rule 1, Sub 4 and 5 of the NICN Civil Procedure Rules 2017 ISO Hold. All sums awarded in this judgment shall be paid within 30 days from the date of delivery of this judgment, filling with the sum shall attract simple interest at the rate of 10% per annum until fully liquidated. This is the judgment of the court.
Most grateful, my lord, for this beautiful judgment. We are grateful, my lord.